We continue reading the Supreme Court case of Andrea Gordon. The bank manager was convicted of fraud. This count, the defendant, that is Mrs. Gordon, pleaded guilty to these offenses and as such may be entitled to a discount. Section 42D of the Amendment to the Criminal Justice Administration Act sets out a tiered system of the possible discount that may be granted to this defendant. These include up to a 50% discount if the defendant pleads guilty at the first relevant date. Okay, 50% discount. Up to 35% discount if the defendant pleads guilty, not at the first relevant date, but before the start of the trial, and up to a 15% discount if the defendant pleads guilty after the start of the trial. In granting these discounts, the court should have regard to certain considerations that are detailed in Section 42H of the said Act. These considerations are: A. Whether the reduction of the sentence of the defendant would be so disproportionate to the seriousness of the offense or so inappropriate in the case of the defendant that it would shock the public conscience. Okay, so even though those discounts are there, right, the judge has to be careful not to apply the discount in some cases, as here, where it would disregard how serious the crime committed is, and members of the public would certainly object to someone committing such a serious crime getting that amount of discount. All right. B. The circumstances of the offense, including its impact on the victims. That is another thing the judge has to consider. C. Any factors that are relevant to the defendant. And D. The circumstances surrounding the plea. And E. Where the defendant has been charged with more than one offense, whether the defendant pleaded guilty to all of the offenses. So the person might plead guilty to some but not all. That wouldn't qualify for a full discount. But anyway, the defendant did enter a guilty plea at the earliest date in the circuit court, and as such will be awarded a discount in this case. The sentencing guidelines. The sentencing guidelines that were launched in January 2018 do not directly assist in relation to the sentencing of these offenses. There is some reference to the Larceny Act in the guidelines, but there is no specific reference to the offense of larceny as a servant. There are two other offenses under the Larceny Act that carry a similar maximum penalty of 10 years, which are larceny from the dwelling and embezzlement by officer in the post office. I paused for a while and looked up the meaning of embezzlement online. From the Collins Dictionary, it means misappropriation, stealing, robbing, fraud. Okay. Continue. For these offenses, the suggested starting point is 4 years, and the suggested range is between 3 and 8 years. I appreciate that these are different offenses, but I will give some consideration as to their suggested range and starting point. I take into consideration that these offenses carry similar penalties and may be viewed as being similarly serious. The Cybercrime Act is not mentioned in the sentencing guidelines, so will not assist in relation to the sentencing in this case. The offenses under the Proceed of Crime Act are not detailed in the sentencing guidelines either. The maximum penalty for this offense is 20 years, so the legislators consider this to be a serious offense. The only assistance given is by means of other offenses that carry similar penalties, such as sections 3 and 4 of the Law Reform Fraudulent Provisions Transaction Act. For these offenses, the maximum penalty is 20 years. The starting point for these offenses is 7 years, and the range being between 5 to 8 years. I will give some consideration to the suggested range and starting point of these offenses. We will look at case law in a separate video.